State Graham, we ready with anyone? You'll have to unmute the jail court.
I guess that would help if I'm talking to you. Yes, sir, we are ready.
I see that the interpreter laptop looks like it's paused, so I'm not sure what's going on with that. You might want to give us some attention. All right, who do I have with me today?
Yes, Your Honor, Toby Heron, a probation violation and felony misdemeanor, Your Honor. I have those case numbers if you need them, or the complete paperwork has been completed, Your Honor.
That's okay. All right, court calls, cause number CR 18-263 and 2020-379, State versus Kobe Alton. Heron, let's see what I have here. Pull up Mr. Heron's case so I can see his motion to revoke. Almost there. All right, Mr. Barron, can you see those on your screen?
Yes, Your Honor.
Give me just a second. All right, Mr. Heron, if you will raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can lower your. All right, Mr. Heron, you appeared before the court at cause number CR 18-263 on August 24th, 2021. You pled guilty to the offense of burglary of a building, state jail felony. The court heard the evidence that day, found that there was sufficient evidence to convict you of that offense. The court reviewed your plea agreement. The court followed a plea agreement that day. The court convicted you of that offense, assessed your sentence at 2 years confinement in the state jail division of TDC, did not issue a fine, but did suspend your sentence for a period of 2 years and place you on community supervision. On that same day in 2000, cause of 2020-37, the court heard the evidence in the Class B misdemeanor offense of driving while intoxicated. The court found sufficient evidence to convict you. The court assessed your punishment at 180 days confinement in the Van Zandt County Jail. Court also fined you $200. The court then suspended your sentence and placed you on community supervision for a period of 2 years. And I believe that that was done in the county court of law here in Van Zandt County. Mr. Heron, it's been during the period of your community supervision that the state has filed each one of these motions to revoke your community supervision, alleging, as you can see here, in 5 counts of the felony case, and 6 counts in the misdemeanor case, various ways they are alleging that you have violated your community supervision. Have you had enough time to review these motions to revoke with your attorney, Mr. Barron?
Yes, Your Honor.
And you feel like you've had enough time to talk with him about these cases and that you've had all of your legal questions answered, and that the paperwork that you've read over and signed today, you understand everything that you read and signed with regard to your plea agreement?
Yes, Your Honor.
All right, Mr. Barron, have you explained the rights to your client to him?
Yes, Your Honor.
And do you believe that he's entering into the plea agreement intentionally, knowingly, and voluntarily?
Yes, sir.
You believe he's also competent, is that correct?
Yes, sir.
And Mr. Barron, does your client waive the formal reading of the state's motion to revoke in each cause? And I'm sorry, I didn't hear you. Did you
Yes,
say
no.
yes? Okay, I'm sorry. All right, court will find that Mr. Heron has waived the formal reading of the state's motion to revoke in each cause. Mr. Heron, I see that the plea agreement in each one of your cases is on the felony case is that you would plead true to all counts in the state's motion to revoke. The state would be recommending that your community supervision be revoked, that you be sentenced to 8 months confinement in state jail division of TDC, and that you pay the balance of your financial obligations, and you would receive 78 days credit towards your sentence for the time that you have spent in jail on that cause. And in the misdemeanor DWI, the recommendation is that your community supervision be revoked, that you be sentenced to 76 days confinement in the Van Zandt County Jail, that you receive credit for all 76 days of time already served, and that you pay the balance of your financial obligations. Is that your understanding of the plea agreement, Mr. Heron?
Yes.
Okay. All right. So at this time, Mr. Heron, I would ask you in both cases, how do you plead to the counts alleged in the state's motion to revoke in each count, in each case? Are those counts true or not true?
True.
Are you telling me that each one of those are true because in fact, those counts as alleged are in fact true?
Yes, Your Honor.
All right. Court will accept Mr. Heron's plea of true in each case respectively. Mr. Barron, are there any objections to the evidence supporting the motion, supporting the plea today found in its waiver of rights and plea of true?
Yes, sir.
All right, court will admit those into evidence. The court takes judicial notice of Mr. Heron's judicial confession. Anything further from the state?
No, Your Honor.
Nothing further, Your Honor.
Anything further from the defense?
No, Your Honor. Thank you.
All right, then based on the evidence before the court finds that Kobe Alton Heron has violated the terms and conditions of his community supervision in both cause number CR 18263 and 2020-379. The court this day follows the plea agreement to resolve these matters. The court finding that Mr. Heron has violated the terms and conditions of his community supervision. The court hereby revokes his community supervision, assesses his punishment at 8 months confinement in the Texas Department of Criminal Justice State Jail Division, orders him to pay the balance of his financial obligations. The court awards him 78 days credit on the charge of burglary of a building. With regards to driving while intoxicated at cause number 2020-379, the court hereby revokes Mr. Heron's community supervision, assesses his punishment at 180 days. Assesses his punishment at 76 days confinement in the Van Zandt County Jail, awards him credit for all 76 days of time served, and orders him to pay the balance of his financial obligations. Mr. Heron, once you do get released from TDC, there's going to be some costs that you still owe. I would ask that you come to the courthouse, take care of those costs. If you can't take care of them all at once, then you should ask for a payment plan and the county will work with you. Okay, sir?
Yes, sir.
All right, Mr. Heron, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with a deputy to be fingerprinted. Good luck to you, sir.
Thank you, Your Honor.
Well, thank you, Mr. Barron.
Mr. Adams, you're up, sir.
All right, Mr. Adams. Are you ready on Leon Baker?
Yes, sir. I am, Your Honor.
All right, Mr. Baker, this is cause number CR 21350. We're set for arraignment on the 3rd-degree felony offense of fraudulent possession or use of a credit or debit card. Have you had an opportunity to go over the indictment with your client?
No, Your Honor, I just pulled it up for Mr. Baker to review. Your Honor, reviewed the indictment with my client. His name is properly set forth and spelled in that instrument. He understands the nature of the allegation against him. We'll waive the formal reading of the indictment. We'll enter a plea of not guilty and ask the court to set us for a pretrial hearing.
Thank you, Mr. Adams. Court finds that Mr. Baker has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record. The court now sets this matter for pretrial hearing. Are you available on either May 9th or May 11th, Mr. Adams?
That would be better, Your Honor.
Did you say the 11th?
11, yes, sir.
11th, okay. All right, court sets Mr. Baker for pretrial hearing on May 11th. That'll be at 1:30, Mr. Baker, as long as you're in custody. If you make bail in this case, then the hearings will be at 9 a.m. on that date, okay? All right. If there's nothing further, then Mr. Baker is excused.
All right, Your Honor. I think that's all I have for the afternoon. Be excused.
Yes, sir. Thank you, Mr. Adams. Good to see you. All right, Mr. Manning, is this Billy Jean Allen?
No, Judge, this is Miss Moore. She was reset from last week. Working out some issues with her plea. We got the paper corrected and she's here to go forward with her plea today.
Okay, I apologize, Ms. Moore. This is cause number CR 18442, State versus Kayla Joe Moore. Ms. Moore, if you'll raise your right hand, I'm going to place you under oath. Ms. Moore, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you, Ms. Moore. You're going to have to speak up a little louder for me today. I'm having some audio difficulties on this side, and so even Mr. Manning's kind of hard to hear. So you're going to have to speak up for me a little bit. All right.
All right.
Mr. Manning, do you have the motion to revoke there for Ms. Moore to review as I go over it?
We've reviewed it and she is going to be pleading true to all counts.
All right. Does she waive the formal requirements of arraignment?
She does.
Okay. Hang on. Did I say formal requirements of arraignment? Does she waive the formal reading of the state's motion to revoke her community supervision?
She does, Judge.
That's what I meant to say and should have said. All right, give me a second here. All right, Ms. Moore, in this cause number CR 18442, you appeared before the court on April 25th, 2019. You pled guilty to the offense of theft of property between $2,500 or less than $30,000, a state jail felony. Court heard the evidence, found that there was enough evidence to convict you of the offense, but the court followed the plea agreement that you reached with the state on that day. The court assessed your punishment at 24 months confinement in the state jail division of TDC. Court also ordered you to pay a $2,500 fine. The court then, based on the recommendation of the state, suspended that sentence and placed you on community supervision for a period of 4 years. And it was during that 4-year period that the state filed a motion to revoke your community supervision, and then subsequently an amended motion to revoke your community supervision. And in that amended motion, as you see here, the state has alleged in multiple counts, a total of 9 counts, various ways they believe that you have violated your community supervision. Have you had enough time to review this amended motion to revoke with your attorney, Mr. Manning?
Yes, sir.
And is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
All right, Mr. Manning, do you believe Ms. Moore to be competent?
I do, Judge.
And have you explained to her her rights as they pertain to this motion?
I have, Judge.
And do you believe that she's intentionally, knowingly, and voluntarily entering into this plea?
I do.
All right, Ms. Moore, I'm going to ask you then, in reviewing the state's amended motion to revoke, how do you plead to counts 1 through 9? Those counts true or not true?
True.
And are you telling me that each one of those are true because in fact they are true and you're not just telling me that to get a certain plea agreement?
Yes, sir, they are all true.
All right, then the court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
That's admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
All right, then the court, having found that Ms. Moore has pled true, the court finds that she has violated the terms and conditions of her community supervision. The court hereby revokes that community supervision, assesses her punishment pursuant to a plea agreement at 9 months confinement in the state jail division of TDC. Court orders her to pay the balance of her financial obligations. And as part of the plea, the defendant is ordered to make a payment of $2,805 to the probation department prior to the plea. I'm assuming that that has been completed. Mr. Manning, is that correct?
Judge, actually, I just looked at the additional language there. Oh, that part was abandoned. She was originally getting a better offer and with a payment up front. That was unable to happen due to that money going to take care of her kids. And so with this new plea, she's pleading to the 9 months without a payment up front.
All right, state agrees.
State's in agreement, Your Honor.
All right, then the court does not order Ms. Moore to make a payment of $2,805 to the probation department. Court does order her to pay the balance of her financial obligations, including $2,500 fine and $313 court costs. The court awards Ms. Moore 202 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Moore, when you do get released from TDCJ, you will need to report to Van Zandt County to make arrangements to discharge the financial obligations that you owe. Do you understand?
Yes, sir.
And failure to do that may result in the court issuing a warrant for your arrest, okay?
Okay.
All right, Ms. Moore, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy fingerprinted.
Okay, thank you.
You're welcome. Who's next?
Judge, I have Miss Billy Allen.
All right, Billy Jean Allen, CR 21-318.
And Judge, while I have been appointed on Miss Allen's case for a little while now, I just learned of my appointment late Friday, end of business Friday. So I've not been able to meet with Miss Allen. I request that she be sent out so we can discuss her case. I've already contacted the DA's office and I have some things to discuss with her that may end up with a resolution on her case sooner rather than later.
Okay, let's place Miss Allen on the contested docket. I'm not saying that it's going to be contested. I'm just saying we're going to put it on the contested docket for April 27th and give you time to speak with the state.
Thank you, Judge. Judge, I believe that concludes my business. May I be excused?
Yes, sir. Thank you, Mr. Brady.
Thank you, Judge.
Mr. Ashmore, good afternoon, sir.
Good afternoon, Judge.
Are you ready on Alex Manis,
We are, Judge. Alex, would you come on up, please?
CR 2182?
Yes. Okay, Judge Alex is back from receiving mental health care treatment. And he's looking a whole lot better than ever in the time that I've had the privilege to represent him. And he sounds better, he looks better. And I've reached out to Mr. Woodwhite, who's not present today. And I don't know if, I doubt Zach or
excuse me, Mr. Wooldridge or Mr. Hartwell have the authority to speak on a case that's been assigned to Mr. Woodwike, but you know, again, this is an evading case. And, you know, the allegation is that he just didn't stop for an officer. And part of that, he was walking, right, on foot. So all that being said, I think we're. Hang on. We're not getting into the facts right now. We're just telling the judge kind of the sequence of how we got here. Okay. And the judge, you know, Your Honor, you remember, and I'm explaining a little in detail for Alex's sake that there were some questions about his ability to comprehend these charges against him. We've had a finding that he was not competent, treatment for that, and that he's been restored and he's back here. And like I said, he's better, looking better, more responsive. And it just seems like he's feeling better than any time I've represented him. I don't think we're long for a resolution. And, you know, of course, I'll always ask for my standing dismissal and an apology, although I know these gentlemen don't have the authority to give that. But if we could have a relatively short reset, I think we can work out an agreement with Mr. Manis, who's not a danger. You know, he doesn't have any criminal violent history or tendencies. He's had some mental health problems, and that doesn't justify any prolonged, I think, and I think the state will ultimately agree with it. It's never been about, you know, Alex is dangerous. It's always been about, we need to do something to help Alex mental health care, make sure he's not a danger to himself or anyone else. Like, not about no violent criminal.
So what I'm hearing is that there's no defensive contest to the finding that Mr. Manis is competent at this time. So you're not contesting the finding. You're just asking for more time to try to resolve the case. Now that Mr. Manis, who does appear to be feeling a lot better, looking a lot better than when I've seen you in the past. Alex, are you feeling better?
Yeah, I'm feeling better.
Good. All right. So let's do this. Mr. Ashmore, if you're available on April 25th, that's just a couple of weeks. We can try to get Mr. Manis resolved, perhaps give Mr. Woodwike a chance to get back and see if you gentlemen can reach an agreement on the case.
Sorry to jump in, Your Honor. I do have a note for Mr. Woodwike. If Mr. Ashmore would be available after Docket to perhaps conference with you as well.
Sure.
There was a matter Mr. Woodwike wanted to be brought up, but not necessarily on record.
I am out on the 25th. Unfortunately, Judge, I could
About the 27th.
actually I'm here on the 27th. So on Nichols, if we need to be here on 27th for Nichols. So I'm here that day and that'll work, and I'll write that down. 27 April.
And Mr. Hartwell, did you say we needed to talk about it today off the record, or is this just something we can take up on the 27th?
I think the sooner the better, Your Honor. But if not today, then perhaps sometime this week.
Judge, I can leave and come to your.
Well, I'm going to be dealing with this docket the rest of this afternoon, and I've got to be at the dentist at 4, so I don't know that I'm going to have a prolonged time to be able to talk about anything.
Go have a seat, Alex.
So unless the state is dismissing the case, I've reset it as soon as I can, which is the 27th. I know we're probably on a ticking time to get the case resolved.
And Your Honor, without going into too much detail, that is what I believe the intention is. There was just one matter that was a little bit delicate before we put it on the record that we wanted to address before entering that.
Okay. Mr. Ashmore,
Yes, Judge.
will you do me a favor? Will you step to your vehicle, zoom in from your phone, and then I'll put us in a private breakout room?
I will absolutely do that, Judge.
All right. I'm going to go ahead and call another case or two while you're doing that. That's the only one you have on the docket, correct, Mr. Ashmore?
That's it for this afternoon. Yes, Judge.
All right, if you'll go ahead and zoom in, then next break I take, I'll get us going in a private breakout room. We'll have that conversation. Mr.
Yes, sir.
Hart. All right, Miss Deputy McLeish, who's next?
Well, Your Honor, Mr. Stevens is not here yet. The only attorney who is present is Mr. Schmidt, who is working furiously, who is still working.
Okay, let him work and then I'll let Mr. Ashmore get out to his vehicle and I'll go ahead and set up a breakout room for us on Mr. Manis.
And Ms. Tabran's asking me to check on the status of the interpreter. Do you have him available?
I do not see an interpreter.
Okay,
And our interpreter is, let's, I need to put back here. Interpreter will be from Mr. Hernandez. Will Mr. Schmidt be ready if the interpreter comes on right at 2?
yes, Your Honor, he is
Okay.
ready.
Okay, all right. So let me see if I can do this quick breakout room and then we'll plan on taking Mr. Hernandez next with the interpreter. And then we'll work our way back onto Mr. Schmidt's cases.
Okay, thank you, sir.
You're welcome.
You said Mr. Stevens is looking at about 2:30, is that right?
on mute. I'm ready on Mr. Hernandez and Mr. Schmidt is. And while we're waiting to get Mr. Hernandez up, Mr. Montemore, if I can have you raise your right hand, I'm going to place you under oath and give you the translation oath. If you'll go ahead and state your name and your license number. Oh, hang on. I've lost speakers again. Mr. Hartwell, will you say something?
Yes, Your Honor.
Okay, I can hear you, but I can't hear Mr. Montemore. Why is that? Are you in the English channel? Oh, maybe now you are. Now you're in the English channel. It's your fault again. I'll tell you what, you can't seem to get nothing right today, can you, sir? Golly, I am 0 for 2 today. All right, Mr. Montemore, if you'll state your name and your license number. Mr. Montemore, do you swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you, sir. All right. Is Mr. Hernandez hooked up and ready to go? Can you establish some communication with him?
Yeah, I would ask the interpreter to let him know. See, okay. Before the record, before we begin, I would like the court to know and have the interpreter relay to Mr. Hernandez that we went over the plea documents with a Spanish-speaking individual in the facility. Explained all the documents to Mr. Hernandez and gave him an opportunity to ask questions. At this point in time, I want to put it on the record to make sure that he doesn't have any additional questions before we proceed based on that language barrier.
Yes, sir. Go ahead.
Okay, so we're good to proceed. Judge, in addition, I don't know if the court has received a copy of the plea paperwork.
I do have a copy of the judgment.
Okay, and I have the plea packet here with me. I'll advise the court that obviously this is a CR 11 indictment. I am about 100% that I am the individual who executed and presented this case to the grand jury initially in 2011. I've made the state aware of that, and I've made Mr. Hernandez aware of that. No one has, obviously, it's been so long, I don't specifically recall, but I've made all the parties aware of that, and everyone was prepared to proceed. In addition to that, Judge, you will note for the court's entertainment that we're pleading to a lesser misdemeanor assault. One of the things that I've done prior to coming to the podium today is some of the paperwork and the plea document would have us stipulate to the accusations as contained in the indictment, particularly on the stipulation of evidence. I'll note for the court, and obviously I haven't had an opportunity to discuss it with the DA's office, that I have interlineated a line on the stipulation of evidence, which basically stipulates to the charges, excuse me, as outlined in the indictment. We would not stipulate to that, hence the plea to a lesser included. Ultimately, I'm not sure that, in the abundance of caution, I may have been overly cautious, but under the circumstances, Ms. Haas not being here, and given the status of the case prior to this agreement, I wanted to make everybody abundantly aware that some of the documents will have some markings on it. The ultimately plea agreement is reached with the state has not been amended at all by me. It's just some of the pre-language, the pre-filled wording, and some of the documents wouldn't apply under the circumstances.
And you said the state has or has not had an opportunity to see what you modified.
They have not, because I did that as I was going over the paperwork with Mr. Hernandez about 20 minutes ago.
State, do you want to review that?
Based off of Mr. Schmidt's representation, I think we'd be in agreement with the specific line that Mr. Schmidt has struck.
And if you can see that. basically, I've lined that out where it states that we agree to the allegations contained in the indictment.
State would be in agreement with that interlineation, Your Honor.
All right, anything further, Mr. Schmidt?
Other than that, Judge, I believe we're ready to proceed.
All right, Mr. Hernandez, sir, if you could raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may lower your hand. Your name is Elpidio Hernandez, is that correct? And Mr. Hernandez, are you a United States citizen?
No.
And do you understand that today's proceedings may result in such a way that your status within this country could be affected? In other words, if you plead guilty to an offense today, it could result in your deportation from the country and denial from being able to re-enter. Mr. Schmidt.
Judge, I would tell the court that Mr. Hernandez currently has an immigration hold or a detainer. He is aware of that. We have discussed the possible consequences of the plea of guilt as pertains to his desire to stay in the country, but once his plea is completed, he is aware that ICE will execute that hold and take him into custody.
Okay, I'm still required to admonish him and have him answer on the record though. So Mr. Hernandez, you heard what Mr. Schmidt said regarding the likelihood of you being deported after you plead to this case. Is that correct? In understanding that you still wish to go forward with your plea agreement today, is that correct? Okay, and Mr. Hernandez, you obviously do not read or speak English, is that correct? And so that is why we are providing you with a licensed translator that can translate from the English language to the Spanish and Spanish back to English today. Are you able to understand the translator in this case? And your attorney in this case is Mr. Richard Schmidt. Are you pleased with Mr. Schmidt being your attorney and the work that he's done for you? And you signed some paperwork here today with Mr. Schmidt, and that's been explained to you in your native language. Mr. Hernandez, do you have any questions about any of the paperwork that you've read over and signed today with your attorney?
No.
Mr. Schmidt, do you believe Mr. Hernandez is competent today? And also, do you believe that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
Judge, through interpreters and discussing the issues with his family members who speak English, I believe him to be competent, that he understands what he intends to plead to, and it is knowingly and voluntarily.
Thank you, sir. And you do believe him to be competent today, correct?
Yes.
Okay. All right, Mr. Hernandez, I see that there is a plea agreement in your case, and it appears that you would plead guilty to a lesser included offense of misdemeanor assault causes bodily injury, with upon conviction punishment being assessed at 271 days in the county jail. You would receive credit for all 271 days. You would receive a $1,000 fine and court cost of $270, reimbursement fees of $535. And also, as a condition of the plea agreement, you will be deported from the United States. Is that your understanding of the plea agreement? All right, so Mr. Hernandez, I would ask you at this time, how do you plead to assault causes bodily injury? Are you pleading guilty to this crime because you are in fact guilty of committing this crime for no other reason? All right, and Mr. Schmidt, is there? Yeah. Oh, sorry. Yes, Mr. Yeah, does he recall what his answer is, or did he not hear the question?
No se escuchó.
Okay. All right, court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the state's evidence supporting the plea?
No objection to the state's evidence, Judge.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state at this time?
Your Honor, just that we've been in contact with the victim in this case, and she is in agreement and supportive of the plea agreement.
Thank you, Mr. Hartwell. Anything further from the defense, Mr. Schmidt?
Nothing further, Judge.
All right, then, Mr. Hartwell, will you give the court the evidence to support the plea?
Yes, Your Honor. On March 3rd, 2011, the victim was with a friend, and that's when the defendant, Mr. Hernandez, came over. They went for a walk and ended up at a baseball field in Wills Point. They sat on a bench, talked for a little while. And then when they went to leave, at some point, the defendant began to kiss the victim and began to remove her clothing. And then that proceeded. The victim at one point tried to stop the defendant, but the defendant did not stop, proceeded to remove clothing, and there was penetration between of genitalia of both defendant and the victim. And victim reported to her mother on March 6th, 2011, the assault, and mother went to Wills Point Police Department on March 7th, 2011.
Thank you, Mr. Hartwell. Mr. Schmidt, any objections or modifications to that summary?
Judge, ultimately, I would concur that the summary given by the state is contained in the stipulation of evidence. Obviously, under the circumstances, we would object to the conclusions made in the stipulation by the alleged victim. In addition to that, we would object to any sexual contact. However, that was the initial allegation as outlined in the paperwork. So from that perspective, we can proceed.
Thank you, Mr. Schmidt. All right, then based on the evidence presented to the court today, the court finds that there is sufficient evidence to convict Lipido Hernandez of the misdemeanor offense of assault causes bodily injury. The court will follow the plea agreement reached between the defendant and the state, and on the state's recommendation, the court convicts him of that offense, assesses his punishment to 171 days, 271 days in the Van Zandt County Jail. The court gives Mr. Hernandez 271 days credit for the time that he's already spent in jail, orders him to pay a $1,000 fine, $270 court costs, $535 in reimbursement fees. And the court, as part of the plea agreement, finds that the defendant shall be deported from the United States of America. Mr. Hernandez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted.
Your Honor,
Yes.
He says he did not hear that last part. Could the translator repeat that for
Mr. Montemayor, it's just a standard statement. If Mr. Hernandez will go with the deputy, she's going to take his fingerprint on the judgment and then he'll be returned to us.
him? It's disconnected with the translator on the laptop. Do you need that? Can I just take him over and get his fingerprint?
What's disconnected?
The laptop, Zoom on the laptop that he's listening to?
Oh, y'all have lost connectivity.
Yes, sir.
Then just, Mr. Montemayor, can you switch over to the English channel and then just say it out loud to him?
We don't hear it.
Did he,
Your Honor, we don't hear it.
you don't hear Mr. Montemayor?
No, sir.
Mr. Wooldridge, you can hear Mr. Montemayor, can you?
No, Your Honor, I cannot.
Really? Okay. Let's see, interpretation.
They're back in, I can hear
Try,
it too.
try it now, Mr. Montemayor. Or flip back over to the English channel and see if. All right, so many issues today. Mr. Montemayor, can you flip over to the English channel and try it again without the translation? Nothing?
No, sir.
Not hearing anything either.
Are y'all hearing me okay?
Yes, Your Honor.
All right, Mr. Montemayor, I've turned off the interpreting.
Let's see. Okay.
Where did you give us? Let's see, go up to them. It's okay.
Good job.
Good job, Mr. Schmidt. I didn't know you were bilingual.
Barely speak English.
All right. Well, thank you, Mr. Montemayor. I appreciate your help today. Have a good day, sir. We'll see you soon. All right, Mr. Schmidt. Appreciate your help throughout that, please.
Yes, sir.
Who are you ready on now?
Real quick announcement on Joe Beatty. Joe Beatty's ill. They brought him in and they returned to his cell. He's aware of what's going on. We intended to enter a plea today, but the state's not ready. So we're gonna set Mr. Beatty for the next available docket to enter his plea.
All right, let's set Mr. Beatty. You want to do April 25th?
But that should be fun.
All right, we'll set Mr. Beatty to enter his plea April 25th at 1:30.
Got Richard Bonin.
Richard Raymond Bonin, CR 22-353 for docket call.
Judge, I'm still working with Ms. Hazel on Mr. Bonin's. We're still working on with Mr. Bonin, Bonin. Mr. Richard here has some additional evidence that he wanted me to obtain and present to the state, which I intend to do that here shortly. So we'd ask to be set for an additional docket call.
All right, court will reset Mr. Bonin for docket call May 9th.
Yes, sir.
That'll be at 1:30.
Taylor Davidson.
Taylor Leon Davidson, CR 2294. Docket call.
That's correct, Judge. We've received an offer from the state, which we intend to accept. Asked that be set for a plea on that May 9th docket. In addition to that, Judge, I'll make the court aware that I did file a writ on Mr. Davidson pertaining to unindicted cases yesterday. They were rejected. I refiled that this morning and served the state. So I will advise Mr. Davidson, if the court grants that and he makes bond, that he will have to appear to enter his plea at 9 a.m. on the same day rather than 1:30.
Is the proposed plea for probation or time served?
It's for a time, Judge.
It's for time. Okay. And do you want to set that earlier than May 9th? We could do that April 25th or April 27th.
We can keep the 9th. That's okay with the court. He's got the reason why we're trying to get him out. He understands that he will be signing for TTC time, but he has a critically ill family member that he wanted to visit with prior to accepting the plea. Understanding full well that it will be he will be taken into custody at the point he enters his plea. So it's kind of what we're trying to get done here, Judge.
All right, court will set Mr. Covey then for plea on May 9th. 1:30 if he's in custody, 9 a.m. if he's on bail. Oh, I'm sorry. I said Covey. Mr. Davidson.
Cornelio Reyes.
Cornelio Reyes, CR 22-114. For Docket.
All right, I hate to interrupt. Previously, Mr. Reyes had other counsel. I can't recall who it was. I took over and I met with the state, negotiated with them and discussed the issues with the case with Mr. Reyes. At this point in time, the state has made an offer which Mr. Reyes wishes to reject. We'd announce ready for trial.
All right, court will set Mr. Reyes for trial. We'll begin that on May 1st for jury selection. And can counsel put on the record what the offer is that the state's made that the defendant has rejected?
Judge, the state offered to abandon an enhancement paragraph and offered 3 years TCJ and I think $1,000 fine, something like that.
And Mr. Reyes understands that the court may not allow him to accept that plea after today.
Yes, sir.
Okay. All right, then Mr. Reyes is set for jury selection on May 1st.
Michael Covey.
Michael Shane Covey, CR 2154, motion to revoke.
That's correct, Judge. I was appointed by the court to represent Mr. Covey, I believe, on Friday. I met with him yesterday morning for the first time. We'd asked for additional setting to have an opportunity to discuss this case with the state.
All right, do you want to set him on the next contested, which will be April 27th, or do you want to go a little later than that?
A little later, if you would, Judge.
All right, so what we'll do is we'll set Mr. Covey then for hearing a motion to revoke May 9th. And we'll go ahead and set for a contested hearing on May 25th. If the resolution is not reached on the 9th, then we'll proceed on the 25th.
Thank you. Sir. 1 second, Judge.
That's fine.
Mr. Davis.
Your Honor, while Mr. Smith's taking a moment, can we go ahead and do Mr. Jake Wheeler? He was on the docket to hire an attorney. He has told me that his family has been unable to do that. He has been in TDC. He's been in TDC for a year. Upon his release, he was brought to Van Zandt County. He does have one asset of 6,500, but he's had no income or for the last year. How long have you been there, Ben? About a year and 2 months.
Okay, so he's otherwise, so the asset's the only thing that would. All right, so the court could find him indigent with ability to reimburse.
So do we want to go ahead and ask Mr. Smith if he
I'll-
would?
I'll let you ask him.
Yes, sir, he is in agreement, but you'll have to show us the indictment.
Show you the money. I'll do it. Hang on.
CR 23. 22.
2322.
Yes, sir. Jake.
Jake.
Wait. He was being released and we had a hold.
Such a great. If the court could scroll down so we can see. All right, Judge, ready to proceed with arraignment. His name is spelled out correctly in the indictment. He understands what he's charged with. We waive formal reading, enter a plea of not guilty, ask for a pretrial setting.
All right, court will enter Mr. Wheeler's plea of not guilty into the records. Court will set pretrial on May 9th. Are you ready on now?
For James Hancock.
State versus James Lee Hancock, CR 22-34354. Is this a plea today, Mr. Schmidt?
We are set for, the state has made an offer which Mr. Hancock has accepted. However, we're not prepared to proceed today. We'd ask to reset that for a plea. The state's offer is to abandon an enhancement paragraph, and ultimately right now it's for pentop. But Mr. Hancock has some things that he had to tend to while in custody before we can proceed.
So what they prepared today, he didn't accept it prior to today, or is he rejecting it, or their state's changing it, or what?
No, Judge. The offer that's spelled out in the paperwork is what we understand the offer to be and what he's accepting. Obviously, given other circumstances, we'd be prepared to plead as offered. If the court would allow us to reset to enter the plea, then we'll do that. And of course, prior to announcing any offer and prior to entering the plea, if the state's so inclined to let me pick at him for a better offer, then obviously I would do that. But as of today, the offer on the table has been accepted.
State, do you have any response?
Your Honor, I have no response.
Okay, so Mr. Schmidt, does Mr. Hancock want to be set for a plea or set for a final docket call or what?
Set for a plea, Judge.
Okay,
Just reset for a plea.
reset for. All right, can we set it April 25th?
Yes, sir.
All right, court sets Mr. Hancock for plea on April 25th. That'll be at 9 a.m. And I was just looking over and I know Mr. Schmidt said that this is not whatever y'all agreed to, but I was just looking over this proposed judgment and I would just point out so that it's not an issue next time. If there's findings on enhancement paragraphs, we can't have a enhancement paragraph true and then a finding on it abandoned. So here where it says true, and let me see if I can find it here, where it says true and then abandoned, those usually don't jive. It's gonna be abandoned here, or it's gonna be plea true, found true, be true, not true. So anyway, just for future, if we're using the same paperwork.
Thank you, Your Honor.
Real quickly, before I have to do some additional paperwork, Judge, DeAndre Davis is on your docket today. Mr. Davis is having some issues in his cell. I think initially he refused to be removed. I don't know. I've informed the jail to leave him in his cell, and I'll announce and go talk to him after. I was appointed on him recently on his motion to the state's motion. And I met with him yesterday morning, so he's aware we're not going to resolve it today. So we'd ask that it be set. Similar to Mr. Covey.
Can you announce anything on arraignment? Do you know if his name is spelled correctly? Can you enter his plea for him?
I can do that, yes, sir. Yeah, he does understand what he's charged with. His name is spelled correctly. Obviously, we wait for him reading that. Enter a plea of not guilty.
Right. Court will find that DeAndre Davis is in custody and the court will waive his appearance in court today upon his counsel's request. The court will find that Mr. Davis, although not in court, has reviewed the indictment with his attorney and his name is spelled correctly, and that officer of the court, Mr. Schmidt, has waived the formal reading of the indictment, and the court will enter his plea of not guilty into the record, and we'll set Mr. Davis for pretrial hearing on May 9th at 9 a.m. Anyone else, or do you need some time?
I need a few minutes, Judge, I think.
Yes, sir.
Yes, ma'am. Mr. Hodges. Well, your choice, Mr.
Mr. Stevens, are you ready on Justin Wayne Hodges?
I am, Your Honor.
All right, CR 22-148. We set for a plea today, Mr. Hodges.
Yes, sir.
All right, Mr. Hodges, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can lower your hand. All right, Mr. Hodges, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with Mr. Stevens and the work he's done for you?
Yes, sir.
Do you feel like you've had enough time to talk with him about the case and that you've had all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Stevens, do you believe Mr. Hodges to be competent today?
Yes, sir, I do.
And do you believe that he understands his rights and that he's entering into this plea intentionally, knowingly, and voluntarily?
Yes, sir, he does.
All right, Mr. Hodges, I see in cause number CR 22-148, you are charged by indictment with the offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams less than 200 grams. The range of punishment for a first-degree felony offense, if convicted and sentenced, would be for not less than 5 years in prison or more than 99 years or life in prison, and a fine not to exceed $10,000. I see that the plea agreement in your case is that you would plead guilty to that crime. The state would be recommending that your sentence be assessed today at 15 years in prison with $180 in court costs, $290, 180 restitution, $290 in court costs, and $90 in reimbursement fees. And you would receive 185 days credit towards your sentence for the time that you have spent in jail on this cause. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Hodges, then I'll ask you, how do you plead to that offense?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court does accept the defendant's plea of guilt. Mr. Stevens, any objection to the state's evidence?
No, no, sir, no objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Yes, Your Honor, I just want to put on the record that there's 3 other cases that my clients, 4 other cases my clients charged with are being declined prosecution. One would be DA number 2022-0381. That's a theft case. Could be declined. Another one is DA 2022-0230. Unlawful possession of a firearm by felon will be declined. DA 2022-0231, a theft of property will be declined. And finally, DA 2022-0228, another theft of property will be declined. I just want to make sure that's on the record, Your Honor.
Thank you, Mr. Stevens.
With that, I rest.
All right. And I see here that there's also a form called waiver of in-person hearing.
Yes, sir.
Mr. Hodges, do you understand that today you would be waiving your right to appear in open court in person, and you are consenting to conducting this hearing via a video conference such as we're doing now? Is that correct?
Yes, sir.
Okay. All right, then Mr. Hartwell, will you give the court the evidence to support the plea?
Yes, Your Honor. On about January 31st of 2022, Constable Burton got a tip about the defendant and the possibility of some stolen property at his residence. Law enforcement kind of set up outside, saw the defendant arrived and proceeded to make contact with him for an arrest. In the vehicle the defendant arrived in, they located white crystal substance. The lab tested that to be methamphetamine in an amount of 12.4 grams, along with some other various paraphernalia. And Mr. Hodges admitted to the possession to law enforcement on scene.
Any objections, Mr. Stevens?
No, sir.
All right, then based on the, and did you say that there was a lab report on that, Mr. Hartwell?
Yes, Your Honor.
Okay, and can you tell me the amount again?
12.4 grams.
0.4, okay. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Hodges of this offense. The court follows the plea agreement today. Court convicts him of that offense, assesses his punishment at 15 years confinement. Texas Department of Criminal Justice orders him to pay $180 restitution, $290 court costs, $90 in reimbursement fees, and awards him 185 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Hodges, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted. you ready, Mr. Aguado?
Yes, sir.
Mr. Aguado, if you'll come up, CR 21-317.
Much better.
All right, go ahead, Mr. Stevens. I think we're just set on a status today. I know that Mr. Aguado was returned to Van Zandt County on March 24th and had an aftercare appointment on the 27th with, I think, Dr. Corman at the Andrew Center.
Yes, sir.
And so any announcements from the defense?
Judge, I think my client's much better position than he was months ago. He's doing good. He understands what's going on. And we're going to request a plea date. I haven't spoken with Tyler lately, but a few months ago, we had talked about a probation with some mental health conditions of it. So we're going to ask to resend the case for a plea, Judge, and I'll get with Tyler between now and then and get the details worked out.
Okay. Joseph, how are you doing?
I'm all right.
You doing okay? Good. Well, you look a lot better than the last few times that I've seen you. Are you feeling good?
Yes.
Good. Excellent. All right. All right, Mr. Stevens, how about, are you available on April 25th? That's 3 weeks.
Yes, sir, I am.
All right, let's do that. Let's set Mr. Aguado for, I'll put status on plea
Okay, so
on on April 25th at 9 a.m. I'm sorry, not 9 a.m. 1:30.
yes, sir. All right, Judge, I'll be accused.
Yes, thank you, Mr. Stevens.
Thank you, Judge.
We'll see you soon, Joseph. Deputy, please.
Your Honor, we do have Mr. Danford in the room. To look at his, what, you've got a message waiting as well, Ms. Taberham.
Hang on. So what do you want me to do? You want me to bring, who is it that you want me to bring up? Danford?
We have a KPS profile, and I sent you a text just a minute ago about the amounts that he owes.
Okay. All right, I'll need time to review that real quick. All right, let me have some time and I'll review that. I'll hop on back. All right, Mr. Danforth, if you're in the courtroom, if you'll come forward. Deputy McLeish, I'm way out of focus here. All right, Mr. Danforth, you're being held on what appears to be 3 warrants for KPS profiling. means warrants for not paying your past court costs owed on previous cases. Those cases and amounts are CR 09-420, wherein you owe $846, CR 10-32, wherein you owe $1,467, and CR 15-358, wherein you owe $2,831, for a total of $5,144. Mr. Danforth, do you have any ability to discharge any of these amounts that you owe?
Not right now. I was paying on them for a long time, and then like the COVID thing hit, and I was working with Bonnie, and I knocked down a ton of it. It was like they were outrageous. I've like knocked out one or two of them, and it just, things got out of hand with COVID, and it just kind of went to the backside of my head, and here lately I haven't been working for the past couple of years, and they're old court fines, and we were, I worked with Bonnie for a long time and was paying on them. I was wondering if I could reestablish maybe a payment plan, or they're over 10 years old.
Yeah, I'm sure that we could do that. Do you have any money to bring to the table right now to show me that?
Not right this minute, but I just posted bond, and if you could possibly set me up a payment plan, I could probably set up $25 a month at minimum. That's what I was doing with Bonnie. And if you could look at the record, we knocked out quite a bit of them.
I'll tell you what I can do. The law would grant you $100 day credit. I could just go ahead and sign an order to allow you to, that you can sit them out if you don't have the financial ability to.
Well, is there any way you could use that towards me being able to get out on the bond and be able to start the payment plan again?
If you were to bring me a payment towards that $5,000 that you owe, you're owing $5,000 and you tell me that you posted bond yesterday, so you have some kind of financial ability.
They sold my motorcycle.
I understand.
Can
I'll tell you what, $500, that's 10% of what you owe.
you give me a week?
I can, yeah, but you're going to sit in jail. You can have as much time as you need, but you're going to sit in jail.
A week to get out to work, and the only way I have is to earn the money, sir. And you can ask Bonnie. I was working with her to get them paid. Like, I was making my payments and everything until COVID hit. And I can pay it off from out there if you give me an opportunity.
Well, it's not about me giving you an opportunity. I've given you multiple opportunities.
Well,
I don't want you to make it sound like I'm denying you something. You were on a payment plan for over $5,000 worth of stuff. And
no, I was on a payment plan for like 10,000 or 14,000. I paid off that much of it, sir.
I know, I understand. It's what you said and what I said is the same thing. I said a payment plan for over $5,000 worth of stuff.
Right.
I'm saying you owe 5,000 right now. I'm saying if you'll give me 10% of that, I can let you out and get you back on a revised payment plan.
10%
10%.
or on setting it out, the 10%.
10% of your total right now would be $514.40. I'm saying if you or your family members or your loved ones or your friends or preacher, congregation, whoever can bring in $500 towards this payment, towards these delinquencies, then I will let you out. I'll give you $100 a day credit for every day that you sit in there until you bring it. And if you don't bring it, then at the expiration of 52 days, you're going to have set out all of this, because you're going to get $100 a day credit for every day that you sit there. And I think the law requires me to run all of these concurrent. So $500 gets you out and on a payment plan. And if not, then you sit there for almost 2 months, and then you've discharged them, and then you just have whatever you're in jail on.
Is there any way you could run them concurrent and just let me sit them out?
Well, that's what I just said.
No, I meant not concurrent, but what do you call it, where they run together?
Concurrent.
Like, it's, like the total is 5,000, correct?
5,044,
But the top one is how much?
846,
The, no, the most amount one's like 2,000 something.
28.
Oh, you're wanting 28 days credit for all of them?
I mean, is there any way I could do that? Please,
That's not what I'm gonna do.
I understand that, sir.
Let me, Mr. Danforth, let me look at it. Let me look at it and see if the law requires me to run them concurrent, then they have to run concurrent. If the law gives me the discretion to run them consecutive, then I'm gonna run them consecutive.
And I'm not understanding concurrent is like where they're one right after the other.
No, that's consecutive.
Okay,
Concurrent means at the same time. So what you're saying and what you're wanting is if the highest amount is 2,800, which it is, then you would ask, you're asking me, Judge, let me sit out the 2,800 and give me credit for those two that are less and sit all of them out in 28 days rather than 52 days, which would be consecutive.
Right.
What I'm saying is let me review the law. If the law requires me to do concurrent, then you would sit out all of what you owe in 28 days. Yeah.
is there any less amount that you would take for the down payment on it?
10% is my customary amount. I think that's fair under the situation.
There's no way I have it sitting in here. I'll have it. I can get it out there if you give me 5 or 10 days to earn it, because I do construction and I've worked. I mean, my hands are my only means of financial. You know, I sold my car, my bike, I sold everything to try to.
Do you have somebody that can loan it to you?
No, sir.
Because you're asking me to give you credit. I'd rather you go to your friends and family and ask them to give you credit.
I don't really have any friends or family. I have a girlfriend that just got out of jail, and she, you know, she's doing bad. We were going to stay at her mom's house until we get on our feet. But I mean, I work. I can make 1,000 or more a week in money, you know, doing construction, or I could do community service too.
All right, let me look it over and I'll get back to you on it.
Okay. And I filed for an indigent attorney. Is there any way? I heard everybody's getting Mr. Smith.
That's between judge and
Oh.
guy.
So talk with Mrs. Abraham and she can tell you about the indigency.
Your Honor, can you hear?
No.
I think there was some confusion over whether or not you were waiting for us or we were waiting for you to look into some matter. I think we're ready.
Let's go. Are you ready on Mr. Smith?
Katrina Anders.
All right, Katrina Anders, CR 22351.
Yes, sir.
Judge, I believe originally we were here for a doc call. We were prepared to enter a plea in which Ms. Sanders would be placed on 3 years community supervision. She is a resident of the state of Louisiana. Her proof of residency is in Louisiana. And the interstate compact issues have reared their ugly head. And I believe perhaps the court and the probation department is uncomfortable proceeding until we get those documents establishing her Louisiana residence. So at that, I've explained that to Ms. Sanders. We'd asked this be set as quickly as possible for a plea. In addition, we would make an oral motion that Ms. Anders be granted PR bonds on her cases that she's being held on and be allowed to go back to Louisiana to get those documents so that she'll have them and be prepared to make her plea when we come back.
Any objection from the state?
Your Honor, since I'm unfamiliar, if I could have just one moment to briefly review the case. Your Honor, state would not object.
Okay, court will set Ms. Anders to enter her plea on Monday, May 9th at 9 a.m. Court will grant the oral motion for personal bonds on, it's just one bond, isn't it?
No, sir. Well, I can't verify that right now, but I do know that she's, it would be bond for the CR 22351, but we were, there's an associated misdemeanor DWI that we anticipated playing to today as well. I believe that she's also being held on that one after prior forfeiture. So it would be that one and a misdemeanor.
All right, there's no motions to revoke or anything. There would be no bond, correct?
No, sir.
Okay. All right, court. And you said is the misdemeanor filed? Is it a filed case?
It is, Judge, and the cause number I have for that one is CR 23-00087.
CR 2387. I don't have that one. Which one is that?
It's a misdemeanor driving while intoxicated first.
And it's a CR 23 case?
It is, and I believe the state filed that was part of our negotiation, so they filed it so that they could get that plea done.
Okay. All right, Mr. Schmidt, if you'll send over an order on the PR, personal bonds, rather, not PR, personal bonds, that the court knows. And Ms. Anders, you're ordered to be back here on May 9th to enter your plea before the court. If you fail to appear, the court's going to issue a warrant for your arrest.
Yes, sir.
Ms. Anders, let me give you a word of caution.
Yes, sir.
Today, I know where you're at. I know that you're not on methamphetamine. I know that you're not drinking and driving.
Yes.
And the state, Mr. Schmidt, we're ready to plea you out today, but there's some issues that we have to fix, right?
Yes.
Concerning your residency. Don't take this gift of being able to get out of jail today. Just go home and get your stuff and be back in May. Don't screw this up by getting high. Don't be possessing. Don't be drinking. Any of those things. will most definitely change this court's view on any plea agreement that is brought back. You understand? All right, so if you, right now, Mr. Schmidt's indicating that it's a probation plea. And that's why I'm granting you the personal bonds, is because if you were a Texas resident, you'd be getting out today. So I'm extending that to you. I'm saying don't screw it up by going out and doing something dumb like methamphetamine, drinking and driving, anything of that. Because if that happens, then that, to me, that's going to tell me that you're not a good candidate for probation. And I'm likely not going to agree to any kind of probation. Okay, so understand what kind of blessing you have today. You understand?
Thank you. Yes, sir.
All right, we'll see you back on May 9th.
Yes, sir.
And Judge, I'll prepare the order for the court when I'm completed here. Would it be all right if I email that to your Ms. Abraham?
That's fine. That's fine. That'd be quicker. You ready on Esteban Mendez?
Yes, sir.
Esteban Mendez, CR 22-400-401. Is this a plea today, Mr. Schmidt?
Yes, Judge.
All right, Mr. Mendez, if you'll raise your right hand, sir, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
All right, you can lower your hand. Make sure you speak up loudly for me so I can hear you and so my court reporter can take down what you have to say, okay?
Yes, sir.
All right, Mr. Mendez, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and with the work he's done for you?
Yes, sir.
Do you feel like you have had enough time to review all the paperwork? And if so, do you have any questions about anything you've read and signed today?
Awesome.
All right, Mr. Schmidt, do you believe Mr. Mendez to be competent?
I do.
And you also have explained to him his rights as they pertain to this case?
I have.
All right, Mr. Mendez, at CR 22-400, the state has indicted you with the second-degree felony offense of sexual assault of a child, which carries a range of punishment of not less than 2 years or more than 20 years if convicted and sentenced, and also a fine not to exceed $10,000. In cause number CR 22-401, you are indicted with the second-degree felony offense of online solicitation of a minor under 14 years of age. And it also carries the same range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. Do you understand the range of punishment for each one of those crimes?
Yes, sir.
I see that the plea agreement reached between you and the state would be that you would plead guilty to each case. And in each case, you would be sentenced to 5 years in prison with your sentences running consecutively. And also you would receive a fine in one case for $2,500 plus court costs of $290 and reimbursement fees totaling $90 in both cases combined. And the state would be taking into consideration, I guess this is a rejection of DA 2022-1236, tampering or fabricating with physical evidence. Mr. Mendez, is that your understanding of the plea agreement today?
Yes, sir.
That's what you're asking the court to approve?
Yes, sir.
Mr. Mendez, how do you plead to sexual assault of a child?
Guilty.
How do you plead to online solicitation of a minor under 14 years of age?
Guilty.
Are you pleading guilty to each one of these crimes because you are guilty of committing each one of these crimes?
Yes, sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
No objection.
States one is admitted in each case respectively. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Just that the state is in compliance with victim services, Your Honor.
All right.
And it also looks like there is an agreed protective order on this, both of these cases.
That's correct. And we've executed the agreed judgment, and it's with the papers.
Okay, I don't have those here, so I'm assuming that's there with you, Mr. Schmidt. You'll be sending it back.
It is, Judge.
Okay. All right, anything further from the defense, Mr. Schmidt?
Nothing further, Judge.
All right, Mr. Hartwell, can you give the court the evidence to support the plea?
Yes, Your Honor, I apologize. I'm looking for the for that now.
And Judge, while the state's reviewing the facts, I would note to the court that Mr. Mendez received chapter 62 supplemental admonishments, which we went through, and he did receive a copy of chapter 62 as well, contained in the plea paper.
Thank you, Mr. Schmidt.
Your Honor, it appears on May 4th, 2022, Detective Wheeler with Wills Point Police Department was contacted in reference to another call. Officer Bo Cook advised Detective Wheeler that there was a 12-year-old female stating that she had been threatened via social media. The juvenile told Officer Bo Cook that an unknown individual added her on the social media app Snapchat and told her that if she did not send explicit images that she would be harmed. Detective Wheeler made contact with the juvenile and retrieved the username from the Snapchat account. That username was eventually tracked down to Mr. Mendez.
Mr. Hartwell, Mr. Schmidt.
Yes, thank you.
I understand that Mr. Hartwell is not familiar with this case. It's complex, and Ms. Heisel had reviewed it, and he's doing a fine job. I would state that in an effort to simplify matters for him as well as the court, initially this particular investigation spurned several different defendants. The initial complaint, as far as the online threats, resulted in a Snapchat account that was tied to another individual that has since pled prior to this, and is not directly related to Mr. Mendez. The state initially indicted him on online solicitation based on those Snap accounts, and then dismissed that indictment because it did not apply to him. The indictment, as alleged now, were related to some what could be interpreted as explicit or suggestive text messages between Mr. Mendez and a stepdaughter living in the same household. Mr. Mendez has been in custody for that particular online solicitation for quite some time. At some point subsequent to that, the same alleged victim requested a meeting with the law enforcement officer who was investigating the case, as well as the district attorney, Tonda Curry, in which she made an outcry of sexual abuse against Mr. Mendez. The state's evidence, as alleged or as stipulated to, ultimately is vague as to the actual outcry or the actual act of sexual conduct that Mr. Mendez has been accused of, but ultimately the facts, if taken, would amount to sexual acts, not intercourse, that went on between him and the alleged victim here in this case. So ultimately, this was a familial relationship that was investigated based on other activities not associated with Mr. Mendez, and we find ourselves here today.
Mr. Hartwell, any objections or additions?
Sorry, Your Honor.
We agree with that representation.
No, Your Honor, we agree with that representation.
All right, thank you, Ms. Sherwell. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Esteban Mendez of each one of these offenses. The court will follow the plea agreement reached between the defendant and the state. Cause number CR 22-400, the state convicts Mr. Esteban Mendez of sexual assault of a child, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $2,500 fine. Court will order this sentence to run consecutively with CR 22-401. Court orders him to pay court costs of $290 and reimbursement fees of $20 and awards him 328 days credit towards that sentence for the time that he has spent in jail on this cause. And CR 22-401, the state convicts Mr. Mendez of online. The court convicts Mr. Mendez of online solicitation of a minor under 14 years of age, a second-degree felony. Assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders this case to and sentence to run consecutively with CR 22-400. The court dismisses under section 1245 a tampering, fabricating DA 2022-1236. Court orders court costs of $290, reimbursement fees of $70, and also awards Mr. Mendez 328 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. Mendez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over with the deputy to be fingerprinted.
You guys still need to do things?
Yes, ma'am.
Okay.
He needs to be joined.
Just have a seat for now, sir.
That's it. I believe that's all I have, other than getting that away forward.
All right. That's all I have on my docket. Let me check with my boss. Stella, how does your docket look?
That's it.
All right. All right, that will conclude the court's business today, and we will be adjourned. You can let Mr. Danforth know I'm going to review that legal issue, and then we'll report back to him on the next step.
Okay, and I'm bringing the papers over and see you in a minute.
All right.